Welcome to our September webinar, a collaborative presentation of the Federation for Children with Special Needs and the Recruitment Training and Support Center. I am Mary Beth Landy, the Training and Support Specialist here at RTSC. Today's webinar is Navigating DCF and the Juvenile Court System, useful information for those supporting DCF-involved students, presented by Elizabeth Mello, LICSW, and Nancy Hathaway, Esquire. Elizabeth and Nancy will introduce themselves as part of the webinar. Welcome, Elizabeth and Nancy. Thank you for joining us today.
Thank you.
During the webinar, please type your questions into the toolbox and we'll try to answer them during the presentation. Past webinars are archived on the RTSC website, along with many resources on trauma and learning, as well as educational issues that impact student and child welfare. Again, welcome, and let's begin.
Thank you. Do you want to introduce yourself first, Elizabeth?
Yeah, I'm going to switch slides, maybe. I know we tested this.
Right. First thing I want to try to do is Mary Beth, is your mic open?
My mic is muted.
Okay. So I am Elizabeth Mello. I am a social worker. I'm an LICSW. I currently work for Committee for Public Counsel Services in the Child and Family Law Division. And I work on care and protection cases as well as CRA cases. My past experience, I worked at NASW for a while, working on professional development programming, much like this. And prior to that, I had several years in residential work with kids in residential.
I'm Nancy Hathaway. I'm an attorney. I work for the Committee for Public Counsel Services, also in the Children and Family Law Division. I'm a supervising attorney in Boston, so I practice in Suffolk County Juvenile Court, Middlesex County Juvenile Court, and the family courts in both of those counties.
Okay. I wanted to give you a little bit of a brief description of us and kind of the perspective we come from in this. So as we both mentioned, we work for Committee for Public Counsel Services and their Child and Family Law Division. CPCS is the public defenders in Massachusetts, so it's the organization that provides public defenders. CAFL is an arm of CPCS, lots of acronyms here. And we primarily work on care and protection in CRA cases. And we could be assigned to represent either a child or a parent in those cases. Could be children as well. And sometimes our client's position is aligned with the department or DCF and sometimes not. And we're discussing the systems today from that kind of perspective. So it might be slightly different than perspective if you worked in a different area. So kind of who are our DCF involved youth? Going into like some definitions. So DCF is, DCF youth is really any child, youth or young adult who receives DCF services. And the typical cases for DCF are, you have a voluntary services or like a clinical case. That is when DCF has an open case with the family is intact, and DCF is providing services and supports to that family.
And just to be clear, that is most of the families who interact with DCF in Massachusetts.
Right.
Most families who are served by DCF are served in the home. They get services, and the case sometimes will close out, and there's never any court involvement. We don't even work with those families.
Right.
We work with a much smaller number of families.
Right. And then the cases that also kind of cross paths, a CRA case, which is a child requiring assistance. If you've been around a while, it used to be called a CHINS case. And these oftentimes DCF, it could or could not be involved. It could start off not involved, they could get involved later, they may never ever be involved in a CRA case.
Those are filed by parents, by schools, by police. If a child is not going to school or if a child is having issues in the home, sometimes those cases get DCF involved, and sometimes those cases just are handled in the court.
And then a care and protection case. This is the case where DCF takes custody of a child, often in an emergency basis. It can be it initially is always temporary, and then it could turn permanent depending on where in the process you are. And then finally we have the PYA case, and cases which these are the permanency for young adults, and these are the children who are 18 to 22 who sign themselves in for DCF support and services after the age of 18. Still not moving.
There we go.
Okay, so the juvenile court, and I may pass this to you,
That's fine.
Nancy. But the kinds of cases that are heard in juvenile court are juvenile criminal cases or delinquencies, care and protection, PYA, which is more like just a followed case, and then the child requiring assistance, CRA cases.
And with care and protection cases, those are typically filed by the Department of Children and Families, usually in situations where they want to get custody of the children in the home. They don't always get custody because it's up to the judge. So sometimes the judge will keep a case open to monitor and investigate what's happening in the home, but they won't remove the children. Sometimes they'll place the children with family members instead of taking those children into DCF custody. So we see all kinds of permutations of custody once a care and protection case crosses the threshold of the courthouse. Juvenile court proceedings are private. The public may not come in during a juvenile court proceeding. The records of those cases are impounded. So there are a lot of efforts made to keep the family's business private within the court.
And then the people who are kind of who's who in the court, shall we say, you have the judges who kind of oversee cases. You have magistrates, which I don't generally touch care and protections, but are more involved in delinquencies. You have clerks who seem to keep the courthouse running, organized, and manage documents. You have probation departments. You have the attorneys, court officers. There are court clinicians, and then CASA, or court-appointed special advocates.
And court-appointed special advocates act as guardians ad litem in these cases. So they will sometimes do an investigation and report back to the judge on what they've learned and make recommendations about what they think is best for a child, which is different from what the attorneys do. The attorneys represent a specific client. So if I'm an attorney and I'm representing a mother, I'm trying to fight for what that mother client wants. If I'm an attorney and I'm representing a child in Massachusetts, I'm also going to fight for what that child wants, even if other people disagree about whether it's the best outcome for that child. So we all have very specific roles that we play in the courthouse. Ultimately, the decisions are made by the judges.
And so DCF, or the Department of Children and Families, this is the child welfare organization in Massachusetts. They're tasked with the protection of children in the Commonwealth. They screen and investigate reports of abuse and neglect. They may refer out to it or work with a DA on specific abuse charges, and they provide supports and referrals to families served by the department.
It's important to remember that the Department of Children and Families is a government agency, and so there are limits on when we, in a democracy, allow a government agency to get involved in the affairs of a private family. And so in order for the agency to get involved and make decisions about something that's happening in a family, they have to go to court, they have to get permission, and they have to meet certain standards of proof to do that. That's where the due process comes in. That's where all of the lawyers come in.
And just a couple of things about DCF. They don't provide direct services, so they do more referrals and supports and kind of referring families out to what is available in the community. And their caseloads, I think, are somewhere between 15 and 20 right now.
Yeah.
And then, you know, it's a tough job, no doubt about it. It's emotionally taxing and difficult work that they're doing. Kind of the hierarchy of DCF from their office perspective. So your office has kind of an area director overseeing that entire office. And then under that person is a resource coordinator and clinical manager. And then there's several area program managers. And you have units with supervisors and workers. So those units are made up of kind of an ongoing team, an adoption or permanency team, adolescent teams, and then an investigation unit. Additionally, there's a family networks group, the legal team, adolescent outreach workers, and service coordinators. And then they have some in-house specialists who specialize in education, substance abuse, medical issues, housing. Some of those specialists are regional and some kind of office specific.
It's important to remember that those specialists exist, because if you're working with a child who has some specific issues, the people that you're going to see most are going to be the ongoing social worker, occasionally a supervisor. You're not going to be seeing the area program manager or the area director or the clinical managers. They're going to be there supporting the ongoing social work staff or the adoption social work staff. But those specialists are in the offices. So if you're working with a child who has a specific medical need, you might want to talk to your social worker about whether bringing the medical specialist into the case would be helpful. There's also a central office of DCF. So all of the different area offices are organized geographically. There's Boston office. Within Boston, there are different offices for different neighborhoods. There's a Holyoke office. There's several offices in Worcester, but downtown there's also a central office that houses the administration that oversees all of DCF. You want me to talk about children requiring assistance?
Sure, would love for you.
So I touched on this a little bit in our introduction. The child requiring assistance law was a big reform law passed just a few years ago to change what used to be called the CHIN system. There are different categories of children, of challenges that children face that can lead to a child requiring assistance petition being filed in the Juvenile Court. Some of those categories are runaway, a stubborn child, which is some fantastic language to describe a child who is not obeying the reasonable rules of the home. So if the rules are unreasonable, this doesn't apply. But if the rules are reasonable and a child is persistently and willfully not complying with those rules, the parent can go to court and say, I need some help. I'm filing a child requiring assistance petition. Habitual school offender is a child who repeatedly gets into trouble at school. A habitual truant is a child who repeatedly and willfully misses school. I think that the number is 9 days. You have to miss 9 days in 1 quarter before you can even before the school can even go to court and say that a child is habitually truant. There's also a very important case decided within the last couple of years in Massachusetts that said that for a child to be held habitually truant, that child has to be willfully absent from school. So if a child's absence is beyond their control, then that isn't going to fall under the CRA law. If a child is absent because the school isn't accommodating their special needs, if a child is absent because of some kind of discrimination, you may be able to say that it really shouldn't be falling on the child if the school isn't doing what they're supposed to be doing. Also, sexually exploited children. So these petitions are typically filed by the police department, and they're children who are at risk of sexual exploitation. A petitioner can be anyone, but most commonly it is the parent or the school. I think CHIN's runaway cases, their CRA runaway cases, I'm still using the old language, can be filed or have to be filed by a police department. And the law, depending on what category you file under, the judge may have the power to take that child and put that child in foster care, or the judge may simply have the power to appoint a probation officer to work with the family to try to remedy some of the problems that are happening with that child. Attorneys are appointed for both the child and the parents if there's a risk of the child being removed from the home. And if DCF gets custody of a child in a CRA case, parents still retain medical decision-making and educational decision-making rights. That's a little different from what we'll talk about when we get to care protection cases.
I just have one question that has been asked is, as far as the truancy law, does that specifically exclude children who are on IEPs? For example, somebody who has severe social anxiety and can't attend school?
They are not specifically excluded. I, as a lawyer, have made the argument that for a specific child with specific special education needs, they can't meet the burden of showing that this child's absence is willful,
Okay.
but it doesn't completely line up with the special education law. So if a child is receiving services in school to accommodate their special needs, and the judge thinks that that's adequate, that the child should be able to attend school, the child could be considered to be truant.
Okay.
Children on truancy petitions are not eligible to be held they can't be put in DCF custody before the case is finally adjudicated.
Okay.
So they're at a slightly different risk. Usually those cases just highlight that there's a problem and get some services in place.
Okay. The other question I have is there a difference in the services, or what was the reason for the name change between, I mean, I still use the word CHINS as well, just from years of experience. Was there a difference in services that was happening with the name change to child requiring assistance?
The old name was Child in Need of Services, and now it's Child Requiring Assistance. To my mind, that sounds like exactly the same thing.
Yeah.
I think that part of the effort in the legal reform was to take the focus off of blaming the child and put the focus on helping the whole family and really marshaling community-based services. So for example, the new law requires schools to have an anti-truancy, a truancy prevention program in place. It requires schools to make certain efforts before they can go to court and file a case. If it's a stubborn child case and a parent files the petition, it's handled a little bit differently than it used to be under the Child in Need of Services. I've seen some changes. The changes have not been overwhelming.
Okay, great.
I think it also funded the family resource centers.
Yes,
Mhm.
So,
which makes a big difference
yeah, so
for families.
yeah, so there are family resource centers around the state
Yes.
that parents can go into, whether they're court involved or not, and get some supports
Mhm.
and so forth.
A lot of the services that are available through a CRA case, through a probation department, or through the Department of Children and Families are community-based services that would also be available to families if they simply walked in and asked for services. Some of them have long waiting lists, and having a DCF involvement or a probation officer make a referral can shortcut those waiting lists. But a lot of the times what we wind up seeing are families who really just want those services and might have made their lives a little bit easier if they'd accessed them directly instead of going through the legal middleman.
Okay, great. Thank you.
I kind of put a Q&A slide here to see if we had any more questions that were appropriate, but we can move along.
I do have another question, but we can actually, it has to do with trauma evaluation, so I don't know if we want to hold on to that.
We can do that a little later.
Okay.
So care and protection cases, which really I think seem to be the bread and butter of the work we do, and they're really a high stakes proceeding because we're really talking about families. We're talking about custody of children and families remaining intact. A care and protection occurs when DCF removes a child from their parents or guardians and takes emergency custody and places them into an emergency DCF placement.
And just to clarify, it also occurs when DCF asks for those things, whether the judge says yes or no. So there will be times when DCF goes in asking for custody and the judge says, I'm going to put some conditions on this family and let the child remain with the family a little bit longer while we keep an eye on what's happening.
So an emergency situation occurs, DCF decides to take custody immediately, and then.
Well, so you're talking about emergency custody. One thing that DCF can do is that they can approach a judge ex parte, which means just the DCF lawyer goes in, no other lawyers are there, and they can say, here's the emergency situation and we need authority to take this child out of the home immediately. That can happen over the weekend, that can happen at night, there's a hotline for judges. So those are the really tragic situations, sometimes a house burns down, a child needs to be go into DCF custody right away. But there are also planned removals. And sometimes those are families that DCF has been working with and things are not going well, but DCF will say to the family, we're going to be going in and asking for custody of your children. Sometimes the families will walk into court with the children by agreement and by agreement to come to court, and then everybody gets appointed an attorney and there's a hearing in court at that time.
Move on.
Yeah.
So here's a timeline, and we may go back to this, but I wanted to provide people with kind of the timeline of a care and protection. The timelines are a guide based on federal laws. Oftentimes cases will follow their own timeline. I rarely, if ever, run into a case that actually 100% follows this timeline. The goals for almost every single case where a child is removed is initially reunification. And often our goal is to resolve a case before you get to the point where we're talking about termination of parental rights.
Yeah.
So who's who in a care and protection case? So we have, much like in our first slide, we have the judge, we have DCF and the DCF attorney. So if you were kind of looking at typical law, that would kind of be the prosecutor or the prosecutorial team.
So the DCF worker is the person that the family may have been working with, and they may be on a first name basis with that person. The family probably isn't going to know the DCF attorney. Once things progress to a point where they go to court, that's when a DCF attorney gets involved.
And then we have parents, and then parents counsel. So again, I think, that 72 or that petition, CMP petition triggers kind of appointment of parent counsel, everybody's counsel for that matter, except for DCFs, and indigency. So the court always appoints counsel, and then probation does an evaluation with families to decide if they're eligible for a court-appointed counsel, and there may or may not be fees. I think fees are often waived for many of our clients.
Well, in Massachusetts, you're entitled, as a parent on these cases, you're entitled to have an attorney, and children are also entitled to have an attorney. So if you can't pay for it, the court will appoint counsel, but you have to be able to prove that you can't pay for it. I'm actually seeing them imposing fees a lot more lately. So usually there's a $150 fee that a parent has to pay just for the appointment of counsel, but then otherwise that attorney is working for, is getting paid by the state to represent that client.
And then parents could hire their own attorney.
Absolutely. There are attorneys who specialize in this field, and some parents do choose to hire their own attorney.
And again, children or a child is assigned a court-appointed attorney. It could be that several children in the same family get one attorney. It could be that each child is represented by a different attorney.
Yeah.
It just depends on if children have the same position or if they have different positions.
Now, can I just ask a question? Yeah. I adopted through DCF.
Mm-hmm.
My kids had the same attorney, their siblings. Is that attorney that we're talking to up to the point of adoption, is that the same attorney they've had all along? So usually attorneys switch for them? No,
usually a child is appointed an attorney at the beginning of the case and keeps that same attorney through whatever the finalization of the case, whether that's reunification, adoption, or the child turning 18 or even older. I have some child clients who are now in their 20s and going to college, and they're still technically in DCF custody. They were not adopted, they were not reunified, and as a result, because they're PYA clients, they're still my clients. Okay. Do you want me to talk a little bit about substituted judgment?
Yeah, I mean, I think it's...
So this is the very, very basic version of a very complicated idea. In Massachusetts, my job when I am a child's lawyer is to represent what that child wants to happen. And even if that child wants something that we as adults might think is a terrible idea, my job is not to go in there and sort of shrug and say, well, they want this, but I don't know. My job is to go in there and fight for what that client wants. If the client is competent to tell me what they want, I have some clients who are babies. They can't tell me anything. In that case, I have to do what we call substituted judgment, and that's very different from a best interest of the child analysis. What I am doing is I look at that child's whole situation, that child's life, that child's siblings, that child's family situation, that child's physical needs and safety, and I determine if that child were old enough to tell me what she wanted, what would she tell me? So for example, if I represent a 2-year-old who has a 10-year-old brother who is saying, our mom is great, we want to go home to mom, we love mom, and the situation doesn't look extremely dangerous and lethal, I might weigh that very heavily in looking at what that 2-year-old would be telling me if that 2-year-old could talk. If that 2-year-old could say what she wanted, chances are she might want the same thing as her older brother. So that's one of the variables that I would look into. There are certainly situations where a situation is so perilous that I would think a child might have a great love for their parent, but a child also wants to be safe, and objectively the situation is not safe. That's where I might substitute judgment and say, I'm siding with the department in this case, and I'm looking for DCF custody or custody to a grandparent or something else. But it's a little bit of mental gymnastics.
And I think it's challenging for outsiders to
Yes.
kind of look at client-directed representation and kind of sometimes wonder why we're advocating against what everybody else seems, or what's best interest, what seems to be best interest.
Particularly when you're dealing with, I mean, I think people understand it more with teenagers, but when you're dealing with that sort of 8 to 10-year-old group of kids who, for example, desperately want to go home to parents who everyone else in the case are saying are not a good idea. We don't usually let 8 to 10-year-olds make big life-changing decisions like that. And we don't in these cases either. Ultimately, the judge is going to make the decision. The way that I think about it when I'm representing one of those kids is that child's desire deserves a place in the courtroom. That child's desire should be part of the decision making, even if it doesn't control the day at the end of the day. And that's what lawyers are for.
Just before, so the court investigators that you list here, we are speaking of the CASAs and the GAOs?
The court investigator is a separate
okay.
function in care and protection cases in Massachusetts. The judges keep a list of court investigators. They have all kinds of different training. Some of them are retired police officers. Some of them are mental health professionals. Some of them are lawyers who do this part-time. And basically what I say to my clients is that the court investigator is the eyes and ears of the judge. If the judge could go out and talk to everybody involved in the case and do their own independent investigation, they would, but they can't. So they send out a court investigator who reads all the records, who interviews all of the parties, who will go to the hospital, who will look at physical evidence and will write up a report that then gets turned into the judge, and the judge can consider that report very heavily in determining what to do with the case.
Okay, great, thank you.
72-hour hearings or temporary custody hearings.
So a 72-hour hearing, we call it a 72-hour hearing, which we should really call them temporary custody hearings because they often don't happen within 72 hours. Under the law, a parent or guardian is entitled to, has a right to, a hearing before a judge within 72 hours of the removal of their child, where the department has to put in evidence showing that it's necessary to take that child out of the home. Those hearings sometimes don't happen within 72 hours if, for example, attorneys are appointed and one of the attorneys is not available, or the court is not available on that particular day, or the judge is not available. So sometimes these 72-hour hearings go out a little bit longer than that. I've also seen them happen in less than 72 hours. But the idea is that no government agency should get to deprive a family of their child or deprive a child of their family without getting in front of a judge and making a showing that there is good reason to remove that child from the home. And those are evidentiary hearings. Those are hearings where the lawyers will do a little investigation and will call witnesses. I've seen temporary custody hearings with expert witnesses. And usually that's, in some ways, I think of it as the biggest fight in the case, and it happens within days of the case beginning, sometimes within days or within hours of me meeting my client for the first time.
So in the resolution or outcomes of these cases, so it's very possible a parent, there's several different, I think you touched on earlier, there's several ways these can kind of work themselves out. Parents, both parents or one parent can stipulate and basically state to the court that they're not currently fit and that they agree that they're not currently fit. And that could result in another parent going forward, or it could result in DCF retaining custody. There could be a conditional agreement, and those can happen kind of in the courtroom, but those can also happen before, where parties agree to like conditions of returning custody.
So just to say what that is, sometimes judges will say something like, if there's one parent, if there are two parents in the home, one of the parents has a serious mental illness that's untreated, or a serious addiction issue, or issues with violence or something like that, sometimes the judge will say, okay, the child can stay with the non-offending parent on the condition that the offending parent moves out of the home. And as long as that is the case, the judge will allow that child to stay in the home, or other conditions that the judge can require of the parents in order to allow the children to stay in the home. But if there is a violation of those conditions, those children will go into DCF custody. So that's one outcome. Sometimes judges will decide that the children have to be put in DCF custody, and then DCF is in charge of where that child lives while the case is pending in the juvenile court. And sometimes third parties come forward, family members, grandparents. I've had children's teachers come forward and say that they're willing to care for children while the case is going forward. And sometimes you can convince a judge that that's the best outcome.
So let me just clarify. The child is then taken into DCF custody, and then the placement is found, such as a kinship placement, or?
There are two different ways that it can happen.
Okay.
If DCF is given custody, that means that DCF is in charge of where that child lives. So DCF can place that child in a group home, in a stranger foster home, or they can approve a family member or approve a teacher as a placement. But that child is still legally in DCF custody, even if they are placed with a kinship resource. Okay. The other thing that we sometimes try to do at the beginning of the case is argue that there's no need for DCF custody because there's a wonderful grandmother with a sterling record who has all of the resources and opportunity to care for that child while this case is pending. And we don't need to put DCF in the middle. There's no need for a middleman here. We can put that child with a family member. If a child is in DCF custody and placed with a family member, that family member gets the resources of being a foster parent. So they're paid like a foster parent, they get health insurance through the department, and there are some other resources that are sometimes available through the department. If the child is put directly into third-party custody, then they don't have those resources. But a lot of families would really prefer not to have DCF so involved in their business.
Right. So I actually have a question that ties into this. In that process, is DCF actively looking for family members at that point, or is it that family members need to step forward at that point?
DCF is supposed to be looking for family members.
Okay.
It helps if family steps forward.
It helps a lot when family steps forward. And sometimes as an attorney or as a social worker on a case, we're out there pounding the pavement looking for family members.
Okay.
To come forward.
And talking with our
Absolutely.
parents about who might they want their child.
Okay.
So kind of the life of a care and protection case, as I mentioned earlier, reunification is usually the initial goal. So you kind of have it two-pronged. You kind of have DCF's internal process, and then you have the court process.
Yes.
So DCF has opportunities within their internal system to change the goal, and I don't know if I can go back. I don't know how to go back in my slides. Can I go back? If we go to this timeline, which is where I wanted to go. So there's certain things that are DCF kind of specific. So you have DCF's family action plan or service plan that happens within 45 days of the case. And that's kind of the roadmap for parents. The DCF sets up a roadmap. This is what you need to do for this child to return home. And it has particular tasks. The court investigation is on the court side of things. Then additionally, DCF has what they call foster care reviews. This happens at the 6-month point, and then every 6 months while the child is in care. And then that's, it's the 6-month mark. And then at the 9-month mark is supposed to be a permanency planning committee or a PPC.
So if the child is still in DCF custody after around 9 months, that's when DCF starts to. The idea of a permanency planning conference is that at that point, DCF needs to get together internally and reconsider whether reunification is still the appropriate goal. So that's their time frame. It doesn't always happen at exactly 9 months, but they will usually get together and determine, are we going to continue to move toward reunification, or are we going to start thinking about alternatives like guardianship, adoption, or other kinds of plans.
And then, and again, I guess I say these times with like 9 months in, they're supposed to have at 11 months, they're supposed to have a permanency plan developed. Yeah. And that's supposed to be presented to the court and all the attorneys involved. And then a month later or 30 days later, there's a hearing. And then again, then you have another foster care review, and then you have a custody hearing somewhere around 12 to 15 months.
So at some point, yeah. So I would say that internally, inside DCF, the time frame is around 9 months. They start thinking, are we going to, if you'll pardon the expression, fish or cut bait here? Are we going to start looking at whether reunification is realistic? The court starts to get antsy around 12 months. The court wants to have some resolution of the care and protection case around 12 months. It doesn't mean that they're going to finalize an adoption then, but they want to know, is this a child who needs to be in permanent custody of the department, which means that we could be moving toward termination of parental rights, adoption, guardianship, other outcomes, or is this a case that we've done what we can, this child is safe to go home and we're going to dismiss this case? So that's what the court is worrying about in about a year. If the department internally decides to change the goal to adoption or guardianship, it doesn't mean that they stop working toward reunification. It actually just means kind of a split in the road. An adoption social worker gets involved with the case, and that adoption social worker starts working toward the goal of adoption, while the ongoing social worker is supposed to continue working toward the goal of reunification. That's what we call concurrent planning.
Okay. Now, I just have one question that does pertain to the timelines. Is the timeline the same for children in group residential placements?
Yes.
Okay.
So when I say DCF custody, that just means that DCF has legal custody of that child. DCF is making the educational, medical, and where the child lives decisions about that child's life. Sometimes those children are with kin, sometimes those children are in foster homes, sometimes they're in residential placement, but the same legal construct of DCF custody is there. So the same federal timelines apply.
Okay.
I think that all said, I have very few cases that follow that timeline.
Yeah.
Those timelines move a little fluid.
Absolutely. And you know what? And they need to.
And yes, as
because
they should.
We're dealing with human beings and families.
Mm-hmm.
But I have noticed that judges start to get a little antsy for there to be an answer right around 12 to 15
Right.
months. They want to schedule trial at that point if the case is still open.
So we talked about concurrent planning, then we have alternative plans, permanency plans.
Mm-hmm.
So we have reunification with the family, but we also have guardianship or adoption, permanency with kin, and then when you define kin, it's a pretty liberal definition of kin. So kin could be family.
Kin can be your math teacher.
Right.
I mean, kin is really defined to mean someone who is known to the child, known to the family, has some relationship.
Yeah. And APLA, which I have no idea what the acronym stands
Yeah,
for, but it's there.
Permanent Planned Living Arrangement.
Okay.
I think it's something like that. But that's only available after a child has turned 16. So for example, I have a child client right now who's 15 who is probably not going to be adopted. He's in a wonderful foster home, but that foster parent is going to continue to need a lot of supports. And everyone is quietly waiting until he turns 16, because then we can stop pretending that we're looking for an adoptive home, which everyone knows is unrealistic, and we can start to have his formal plan be APLA, which means that we are looking to provide him with the skills to eventually live independently, and we're going to support him knowing that he's going to remain in DCF custody, and everyone's going to be okay with that, because that's probably the right outcome for that child. But that's where the requirements of the law don't always neatly fit the requirements of the individuals affected by the law.
And can I just ask about the guardianship adoption? Is it considered guardianship leading to adoption, or are there situations where people have guardianship? And is that guardianship, for example, I have a friend who has made me, should something happen to them, be the legal guardian of them. Does that play at all into the DCF?
So guardianship, the idea of guardianship, if I am your guardian, it means that I am legally responsible for caring for you, right?
Oh, would you
so
please?
we put documents in place that, you know, if I were to get sick or lose my ability to make decisions, somebody could be my guardian for legal purposes or financial purposes. That's sort of what the idea of it is. In this context, we see two different kinds of guardianships. We see guardianships after there has been a termination of parental rights, and in which case it's very similar to an adoption, but often those happen when a child is with family members, where for developmental, psychological, family harmony reasons, nobody ever wants to say to a child, particularly an older child, that's not your mother anymore. You have a new mother. We may be comfortable saying that to a 2-year-old. We're not saying that to a 16-year-old. So even if a mother's parental rights have been terminated, sometimes if a child is with family members, they'll make that a guardianship. It is, that person has every bit of the authority that an adoptive parent has, but they're not called a parent. And sometimes that's very important for everybody who's involved. They want to remain the auntie or the grandparent, whatever. There is also guardianship without termination of parental rights, and we see that probably a lot more often. Sometimes those are children who are in a kinship placement where the parent is currently unfit. Either everyone agrees that the parent is currently unfit, or the judge has decided that the parent is currently unfit, and yet they're not willing to say that that will necessarily persist forever. So they're not going to terminate that parent's parental rights. They're going to leave that door just a little bit open and put that child in a guardianship with the foster parent or the grandparent or whoever, so that if down the line things change and the parent is fit and wants to go back to court and say, hey, I'm in a different place now, and now I can take care of that child, there is that avenue that you can do that. But you can only do that if there has not been a termination of parental rights.
Okay, great. Thank you.
Termination of parental rights falls to both parents.
Yes.
So they can't terminate on one parent. They have to terminate on both parents to open a child up for adoption.
Right.
Any more questions?
Yes. They're actually evaluation questions, so I'm not sure whether we want to dive in now.
Why don't you ask it and we'll determine now's the right time.
Okay. The first question has to do with the trauma evaluation. And who determines if a child who's in DCF custody can have a trauma evaluation, and who would be the person responsible? I'm looking at Elizabeth here.
Clinicians?
Yeah, exactly, the clinician. Determining if the child is living in a group home setting about having a trauma evaluation, because I know as surrogate parents, a lot of times there's trauma. Right. I mean, there is, and I do a lot of trauma trainings, there is no child who's in DCF custody who has not experienced trauma in the first place, and then being removed from your family is traumatic again.
Yes.
So a lot of times there are there are questions about wanting more information and getting to the depth of the trauma. And I think that surrogate parents have a lot of questions about being able to get trauma evaluations. Where can they get them? Who can authorize them?
I can answer the legal question.
Right, like, so let's, yeah, so
If
there's two sides of this.
That's right. If the child is in DCF custody, DCF determines if the child can get a trauma evaluation.
Right, it's considered a medical evaluation.
Right.
And
If-
it could be funded even by DCF. So if you
Correct.
can't find insurance or there isn't like a medical reason for it.
On a practical level, if an ed surrogate parent is concerned, it thinks that a child should have a trauma evaluation and DCF is not making that happen, talk to the child's attorney. I mean, if there's one takeaway that I can put in this whole thing is, if you have an issue, if you have an issue with the child not getting something that the child needs, or not in the right placement, or not getting what they need, talk to the child's attorney. Because children who are in permanent DCF custody still have attorneys. They might not see us very frequently, but you should have our number and you should be calling us, because sometimes if DCF isn't authorizing a trauma evaluation, we can get a court to order them to do that under limited circumstances.
Okay.
But we can be helpful. In terms of what happens with the trauma evaluation, I turn that to you.
What happens with it?
Yes. Who does it and the mechanics.
Yeah. So, I mean, who does them? I mean, I think the same people who you would do it, you would request if you were a parent looking for a trauma evaluation. I mean, sometimes it is, much like most evaluations, you're kind of searching out the person who's going to be the right fit. So I think you would start kind of with your pediatrician, your medical providers, or your psychological providers or psychiatrists, mental health team, and see who they would recommend. I could, right offhand, I wouldn't be able to give you a list of trauma evaluators. I have to go back to my computer, kind of search it up.
Call me, I'll give you the list.
Excellent. Call the Federation, because they have lists of people. But I think you want to suss it out a little bit, like any evaluator. You want to kind of make sure it's the right fit. We get evaluations for clients, court funded evaluations, and we're careful about who we want doing evaluations. And there's nothing worse than getting an evaluation that doesn't have value, or in the end doesn't tell you anything or doesn't offer you guidance. So that's my
Or re-traumatizes the child in the process.
right.
Absolutely.
And I think really establishing is, that's a good question to begin with. Is this evaluation, what are we going to get out of it, and is that appropriate in this situation? Is it, is there something else you can do that isn't going to re-traumatize a child?
Okay, great. I have a question from an ed surrogate parent who feels that they're often the last one to know when a child has been, a child that they've been assigned to has been reunited, or the placement has changed. And
I challenge that, because I'm always the last one to know.
Okay, so there you go, Michelle. So I think they're looking at they find out in an IEP meeting that the placement is changing, and really my recommendation is usually having really good collaborative communication with the DCF worker.
Yes.
And I guess the other question I would have is the best interest determination meetings, are they being utilized for surrogate parents to be able to have a voice in what might be the best placement educationally for the student, and therefore where they're going to be living?
In terms of how to get that information, I think having ongoing communication with the ongoing worker is the best way. I can't always speak to the ongoing social worker. I have to go through the DCF attorney, so that's one more layer where we sometimes don't find out. Also be in touch with the child's attorney, because sometimes we will know first, sometimes you will know first. We should all be getting each other in the loop, so that's really helpful. In terms of who goes to the meetings, do you know the answer to that?
Who goes to the best interest meetings? I'm not even sure I know what have heard of such
Exactly. Well,
meetings.
I am not invited to.
Yeah.
Are you talking about internal clinical meetings at the department to
Yeah.
determine where a child should be?
Yes, the best interest determination meetings through ESSA, listing that there are meetings based off of what is the best interest of the child in new placements, changing placements. Obviously, a residential placement is going to affect their educational placement.
Absolutely.
And that's really where a lot of surrogate parents have frustrations, because the student is doing very well in their placement, but let's say they have a truancy issue, or there's some other issue with the resident. They're not doing well in the group home. So the determination has been to move the group home into, say, a residential school, and that school may not be the best place for the child to be going for educational reasons. So there's a big frustration, I think, on the surrogate parent level, as you can acknowledge.
So, yeah, this is tricky, because, once DCF has custody, they really are the person who's making choice on where a child is placed. Now, can they be swayed? Possibly.
Yes.
I mean, this is kind of one of those scenarios where I would say get in touch with your child's attorney and work closely with them, because there may be legal avenues to kind of stopping a movement, like a new placement, from happening. I mean, having been on the residential end of things for many years in my prior career, I also understand from a residential perspective, sometimes you have a child that's not a good fit in a residence, and like that is not appropriate either. So sometimes I think you've got both. You've got a lot of things coming in at play. You've got a residential program that's saying this isn't an appropriate placement. You've got DCF saying we got to find an appropriate placement. Sometimes no such placement exists.
Yeah.
But you've got an ed surrogate parent who, if they're doing their job and doing it well, should be strongly advocating for what is the appropriate education placement.
And I can tell you, I'm not in the room for those meetings. I'm not invited to those meetings, and I don't know technically whether ed surrogate parents are supposed to be invited to those meetings. But what I do know is that the people who are in those meetings are people who can also be influenced outside of those meetings. So if the ed surrogate parent is in constant communication with the ongoing social worker and is using their position to educate the ongoing social worker about the educational needs of that child and the specific advantages and disadvantages of that child's school, then I would think that the ongoing social worker would be bringing that into the meeting, and that would be part of, not the entire calculation, but that would be part of the calculation. So that's a place where I often say among lawyers, most of our advocacy goes on outside of the courtroom. We accomplish very, very little in front of the judge. Most of what we do is negotiate cases in hallways and on phone calls and in emails, and by attending the meetings that we are allowed to attend, and influencing the people who are going to be making the decisions. So ed surrogate parents can do the same thing.
Somebody just wanted a little repeat on the funding for trauma evaluations. Now, DCF can fund them if they find it to be appropriate to do so?
Yes.
Okay.
If a child is in DCF custody, absolutely. If a child's not in DCF custody, it gets a little trickier, but if a child's in DCF custody, DCF absolutely can fund them.
Okay. Because I have someone who I guess is struggling, it's the same person asking a couple questions, is that they've been in touch with the child's attorney, and she said that if DCF doesn't want the trauma evaluation, the court can't require it.
DCF decides whether there's a trauma evaluation or not with a child in their custody. So if DCF, as the custodian, decides that they don't think that a trauma evaluation is necessary or appropriate, then the only way to get the court to force DCF to do that evaluation, fund that evaluation, is for me to bring a motion to the court saying that their clinical decision-making is arbitrary and capricious. That is a very high standard. It is extremely rare for a judge to overrule the clinical decision-making of DCF. There are sometimes other ways as a child's attorney that I can access funding for a trauma evaluation, but that just gets a lot more difficult.
I'm just curious on that case, if
Mhm.
there might be an avenue to request a trauma evaluation as part of the educational evaluation
Mhm.
process.
Right. I do believe that it's very rare that a school pays for the trauma evaluation, at
Yeah.
least the dollar amounts that I know of for
Right.
what they run for.
Absolutely.
But I definitely do understand that. Okay, there's a couple of questions that I think that I'll get back and answer to the group, and it has to do with the complex trauma evaluators, which people seem to be asking for. They're asking what type of training do DCF investigators receive aside from your social work training? For example, investigating report writing. Also, what kind of training is provided for DCF workers regarding surrogate parents?
I have no
Like
idea.
how much knowledge do DCF workers get about the surrogate parent program and their role?
And then I guess that's another training, because we're coming at this from CPCS. So
Okay.
I don't know specific ins and outs about DCF training
Correct.
and what is entailed to be like different, an investigator versus an ongoing worker. I know that they have pretty extensive early on training, but my experience with most DCF workers is that their knowledge on special education and needs of children is very, very limited. Frankly, I go to most meetings and they're looking to the schools to be the experts, like many of us do. There's not a lot of questioning from that perspective. And that's kind of where I look as kind of a social worker working as part of a child's attorney team, where that's when I oftentimes will be turning to a surrogate and parent and kind of having a conversation.
Okay.
Because oftentimes I'm thinking that person is one of the most knowledgeable people in the room
Yes.
about the process.
Yes.
Um,
So the only other question is, how would a surrogate parent find out who the child's attorney is?
If you know where first of all, the social workers should be able to find that out. The DCF social workers should be able to access that information. If you know what court you're dealing with, I think you can call the clerk's office and say, I'm the ed surrogate parent for this child, and I need to know who this child's attorney is, and they should be able to look it up for you. And I think that while these are impounded cases, I think if you identify yourself as the ed surrogate parent, they should be willing to give out that information. Some courts are more cautious than others about disclosing anything over the telephone.
Okay.
So you might have better luck in person or going through the DCF worker.
And that's when you'd want to have your appointment letter that states
Absolutely.
that you've been appointed by
Yes.
the state.
Absolutely. A lot of stuff we've covered, but it's just who's who in the life of the DCF involved youth. And this is like, for me, the child. I want to remind people, if you're a surrogate ed parent, that, meeting with your child client, meeting them in person, getting to know them and what they want is key. There's also parents and other involved family members. So oftentimes there is a parent who has history that maybe the department doesn't have, or there's other family that has history. Again, DCF worker and their supervisor, or the ongoing or adoption worker and their supervisor. And I will say that ongoing workers are out of the office more than they're in the office. It is not inappropriate if you can't get in touch with the DCF ongoing worker to call their supervisor.
And we do tell them that as part of the training and explain court days. And
Right. The supervisors are almost pretty frequently in the office.
Yes.
So then you also have like a foster parent or a residential care manager, case manager. So I oftentimes, these are people, again, that I would love for people to be kind of reaching out to. The attorneys, you have a care and protection attorney. Again, most surrogate ed parents are going to be assigned on a care and protection. It rarely would happen on a CRA. So there is a CNP attorney. There could be a CRA attorney, and there could also be a delinquency attorney. And sometimes those attorneys can be the same.
Yes.
There's school staff, teachers, team chairs, liaisons, guidance counselors, the various specialists, outside service providers, doctors, medical, church and spiritual supports, coaches, teachers of the arts, and then anyone, I guess, the child identifies as important in their life. I've run into a few cases where I feel like, and that's kind of what initiated this training, was that people didn't know who was who in the system, or who they should be in touch with. And then kind of best practice, and I think you touched on this. I think, meeting and talking to your child client and knowing what his and her goals are. And I guess, when we're talking about a surrogate ed parent, we're talking about educational goals.
Mm-hmm.
So knowing what that child's goals are. What does that child want? I mean, we've got kids who are in an out-of-district placement or in like a classroom that's, sub-separate, and then, they want to go back into regular education. And what does that, and at least voicing that want and desire for the child. It may not be an achievable goal, but at least I think putting voice to it, and this is what they want, and what would they have to do to get there? And so that a conversation can be had with a child about, you want this is what has to happen for you to get there. Okay. Get your kids' records. I don't know how much you guys get. I know sometimes how hard it is for us to get records. But getting a hold of records and getting whatnot, the collateral list, again, asking who the child's attorney is. And resources that are already available to the child to help you. So we are a resource that is already available to the child. Same goes for like a clinician, therapist.
And we don't always have to reinvent the wheel. Sometimes just by talking to the people who are already on the ground and have already formed some relationships, we know some things that can save you a lot of legwork and a lot of paperwork to figure things out.
I think the definitely the best practice, and kind of summing this up, is working collaboratively with the people who are already in place. Everyone has their own knowledge base, and sharing that knowledge base makes for a much better, a smoother case. Is definitely true for the surrogate parents and foster parents. Right. So,
okay.
All right. Well, thank you very much.
Thank you.
Yes.
We appreciate your coming in, and that was extremely informative. I'd like to remind everyone that you'll receive a follow-up survey, which we ask you to complete. We value this information so we can provide everyone with the most effective information to support the wonderful work that you do supporting your children. As a quick reminder, please remember to sign up for the October webinar, The Role of Education Coordinators, which is one of the roles that we briefly touched on today, which is October 16th, and it will be presented by Janet Duncan, Kathy Monahan, and Karen Collins, who are all education coordinators. Also, registration is open and filling up fast for our November webinar, College Considerations for Students with Learning Differences, What I Should Expect, with Rachel Mason from Beacon College. So please sign up for those. And please mark your calendar. Our big annual conference, RTSC's 7th annual conference, Making a Difference, is held on Tuesday, November 27th at the Best Western Conference Center in Marlborough, and registration will open soon, I promise. And thank you again, everyone, for joining us, and have a great day.